Moving ahead, now let's dive into the strategic domain of risk management as we explore the nuanced landscape of intellectual property risks. This session will provide insights into effective strategies to safeguard and navigate the dynamic world of IP risks. Allow me to introduce our moderator, Ms. Madhuri Roy, partner Cooley LLP. Dr. Roy focuses on developing and implementing comprehensive patent portfolio strategies for biotechnology, pharmaceuticals, and chemical companies. Open Invention Network and founding partner of Legalitech. Mr. Nair advises on open source issues and represents Open Innovation Network. Lastly, Dr. Tarakranjan Gupta, Senior Principal Engineer, Baxter International. Dr. Gupta has a background in membrane separation science, his work focusing on combining water treatment expertise with intellectual property analysis. Okay, a little change. Instead of Mr. Anand Shetty, we'll be having Ms. Taruna Gupta, Head IP Governance Training and Assessment from Tata Consultancy Services.
Good afternoon, everybody. I'm Madhuri Roy, as just announced, and thanks to the conference organizers and the attendees for this opportunity. Look, the topic before us today, managing IP risks, is a pretty huge topic. It's infinite, in fact. And what my colleagues and I hope to do today is to share with you some of our perspectives, which come from different technology domains and different kinds of risks. And we hope to share with you our perspectives and leave you with some concepts and insights as you go back to your everyday jobs. I also realize it's lunchtime. And what we'd really like to do is make this interactive. So if you have questions when we're talking, please just raise your hand. It's not meant to be a lecture. And so then we can get to lunch faster. What I thought I would do is just take a minute, and each of us can tell you what we do in our everyday lives, because they are actually quite diverse, and I think that's what will make this panel interesting. And then we'll sort of do a round-robin set of questions, and then get some of your questions as well. Since I'm holding the mic, I'll just briefly mention I'm a patent strategist. I work in the biopharma space. I work with small and innovative and emerging companies helping to protect their IP. And as they start to grow and look at third parties, help them manage their third-party risks. I also work with investors, helping them look at target companies and assess IP risks before they make investments. I'll ask Taruna to talk a little bit about what she does.
Thanks, Madhuri. A privilege to be on this panel and looking forward to sharing perspectives and experiences with all of you. So I'm Taruna Gupta. I have been with TCS for the last 28 years. In my current role, I head IP governance, training and assessment, looking at IP risks in both the product space as well as the services space. And I'll hand over the mic now to Biju for his quick introduction.
Yeah, my name is Biju Nair. I'm a lawyer by training, and I look into open source. I also represent two global communities. One is called Open Invention Network, which is a defensive patent strategy against patent trolls. And we protect Linux and open source in the community. The other community I represent is called LOT Network. LOT stands for License on Transfer. So we are protecting, that's again a defensive strategy, where we protect companies from the patent trolls. So Linux and open source is, OIN is limited to Linux and open source. In LOT, we protect any patents which is sold by a LOT member globally. Thank you.
Hello all. Myself, Tarakranjan Gupta. And my IP journey started with General Electric in 2005, so almost 19 years. And I worked as IP analyst in GE, and then patent strategist in Shell, the oil company, then Baxter company, as well as Living Guard, and now I'm in the Baxter. And my role in Baxter for the last 4 years is like the double hatting. I am the IP focal point and strategist for the Southeast Asia for the Baxter. You know that renal dialysis as well as medical instrumentation company. Also, my role as a water innovation tech lead for the Southeast Asia. So I am also the creating problem And I am also the receiving problem as well. So that's me. And apart from, I am also a writer for the books for the IP strategy. And today I'm here as one of the panelists, as you see. Thank you.
So before we get into the questions, just going back to the concept of how infinite IP risks the topic is, right? It cuts across jurisdiction, cuts across types of IP, whether it be patents or trade secrets, know-how, software, trademarks, copyrights, publicity, etc. Cuts across contexts, in the context, of course, protecting your own IP, in the context of collaborations, agreements, mergers, acquisitions, as well as third-party assessments and several more. And so maybe I'll start with, since you have the mic, Tarok, what keeps you up at night? What's the kind of IP risks that you have to, give an example of what you contend with on a daily basis and steps you take to mitigate it?
Yeah, thanks. I will first will say that in my present company and role, the first and foremost line is, we will not file any patent if not absolutely necessary. And that sounds a little bit of awkward, maybe because we are all here in this IP conference, and I'm talking about not to file a patent. Because see that in particularly this company is a medical instrumentation company, or medical, I will say that treatment delivery company, like the Baxter, like the Medtronic, like that Fresenius Bio. The issue is like that, the main technology, the master technology is more or less same for the renal support, for the organ support. Only there is a tweak, little bit of change of design or therapy, or actually I will say the recovery, and that change obviously is, I think, the enhanced efficacy. That's why we provided the patent right. But the risk is like that moment we publish the patent application even, then our competitor will say, okay, they have published this, and it is not easy but possible to design around. That is the one thing. That means we have to understand the risk if we are going for the patent filing, or in the last session we have heard that sometimes you keep it as a know-how and industrial secret. That's one. And I have this here, actually I've written down, what is the possible IP risk? It starts from the thinking of the whether you're going to file or not. To be or not to be, that's the question, like that. And as I mentioned, it's easy to design around. And demonstration of the technology, because suppose that we have filed an IP, and after that we go to this market, I think in form of the patent, in form of even the trademark, and these two have a more risk that, okay, reverse engineering, we are talking to you actually yesterday, that was reverse engineering. Easy to do reverse engineering, not very difficult, not easy, but not very difficult, to have a prototype that is have similar efficacy or similar, I will say, the efficiency that we have. So, like the Coca-Cola example like that, we don't want our competitor to go inside. And that is the risk that we are involving. And also, still we file the patent. And when we file a patent, and I, as a Asia Pacific lead for the IP focal point, I ensure that we have a mitigation plan. So whether we will also tell a little bit about the mitigation plan, should I? Or
why don't we identify our risks?
Yes, then actually go to the
how we mitigate our, how we sleep.
So am I clear about that my risk, is it? Because you can ask me the questions. Is it not very much usual that what I speak, that my pain about that? It can be, it is not like that, I will say that transfer of the knowledge by means of publishing the patent or publishing the information on the open forum. I know that we are getting exclusive right, but there is a flaw. The exclusive right also comes with a risk that anyone can change a little bit, sufficiently little bit, and then it will become a more competitor, and they can build up the new technology on that, I think.
Absolutely. The to be or not to be is a very fact-specific, situation-specific point.
Yeah. So I would look into the two types of risk today. One is the open source risk. So today, when we look at open source risk, please understand that there is a huge supply chain in the open source. So you'll be working with vendors across the globe. If somebody in the supply chain, and this is irrespective of the technology you're using, irrespective of the jurisdiction you are in, there is a risk. So how do you ensure that there is a compliance in the whole supply chain of your software? Because everything today is revolving around software. So there is risk associated with, from a data protection perspective, but for example, there is a data breach because there is vulnerability in your software, because one of your vendors did not take due care. So how do you ensure compliance in the whole supply chain? Whether you are working for a vendor, you are working for the ultimate customer. Because if I have to sue any entity, I don't know who are the vendors. So in COVID times, when I sent legal notices for AGPL non-compliance, I saw that ultimately the banks were not the violators. It was the system integrators and third-party vendors who were the violators, actual violators. So how do you identify the risk? First is the open source risk. What is the consequence of that risk? So it could be data protection, data breaches. So that is a different aspect. There is a damage and compensation you have to provide. You have to inform the customers. That's one side of set. Then there is a non-compliance risk. So in today's time, previously only your, so today you could be, the risk is also from your competitor. Because if you are non-compliant, your competitor could sue you because you have released the product into the market faster than him. So it could be an antitrust issue also. The other issue could be that you have not complied with the license obligations. So the problem today is that if you ship the product, you have to pay damages, recomply with it. So there is a reputational risk at stake. If you are a listed company, your share prices goes down. At the end of the day, you have to again comply. Let's say if it is a GPL compliance, they have to do the GPL compliance then. So it is always better to identify the risk. And what is the solution? So maybe I think I will leave the solution to the next part.
Yeah, thanks. So extending what Tarak and Biju mentioned, I'll share some of the perspectives here. While they may be experiences from my own organization, I would expect that similar scenarios exist in other organizations of the same scale or otherwise. So in an organization where there are multiple parties interacting within the internal ecosystem, and the final outcome that is delivered to the customer is in the form of a product or a service, we're dealing with the product owner at one end, we're dealing with the team that provides services to the customer at the other end. We have other teams that are involved, teams that are contributing to the differentiating aspects of the product or solution to say, and hence filing for IP, whether it is patent, copyright or trademark. Then we also have teams that are responsible for the sales and marketing function. It is very, very important to ensure that every person in the ecosystem understands how his or her action can contribute to either creation of a risk or mitigation of the risk. Let's say that a person has joined the organization, and as all of us are aware, we do expect them to have basic IP awareness, but it is important to make sure that they are also aware of what should not happen, right? So when they are developing a particular product, providing a particular service, are they doing the right thing or are they doing something that they should not be doing? When a person in the sales organization is selling an IP to the customer, and in an ecosystem that involves the organizational IP, a partner IP, a vendor IP, what should or what should not that salesperson be doing? What is the message that should be going out to the market? What is the perceivable risk within the organization as felt by the internal stakeholders? But how is the market looking at the organization in terms of the risks that are inherent in every product or service that they consume? So we'll again go around the table and understand from Tarak and Biju and all of us what the solutions are, and then I'll also cover the solutions and the proposed mitigation measures from my side.
Absolutely, and just to round out risks in the biopharma space, again, the to be or not to be question is faced, but in technologies where from conception to, from concept to bedside, if you will, in the therapeutic space, for example, can be at least a decade. And in some particular fields, IP is all you have. And so there's often a risk with not filing that IP, or that tension between filing and giving it away, but also protecting your assets. And so often these issues are very fact specific, and I agree with Taruna, a lot of this is education based, right? So we as professionals, whether we're in a law firm or whether we're managing folks in a company setting, is educating our teams so that they are enabled to issue spot and come to you with the facts of their situation. In terms of mitigation of risk, right, you can have proactive mitigation or reactive mitigation, and that's something that Tarak and I were speaking about yesterday. Maybe you can pick it up from there, right? Because if proactive mitigation is probably the best because you're prepared and you're strategic, but I'm sure you will agree that many of our jobs sometimes is a reactive mitigation, and that's fact of life, and as long as you have a roadmap to do that, you can be prepared to address.
Yeah, thanks, Madhuri. That's, she was talking about the proactive and reactive mitigation, and I will give a couple of examples, kind of. And rightly she pointed out the educating the team. That's also important, the R&D team particularly, the what to do and what not to do. Better actually what not to do. That's important, rather than what to do. So I will say that one example, I think that I can share this because it happened, and we are able to solve the risk, that's why, without naming this company. We were about to develop a filtration system. And we went to a company in Denmark, and we are trying to have a collaboration with them with osmotic barrier, osmotic membrane. And obviously we had the $1.5 to $2 million, and it was a one, and particularly I was leading the project. See my situation. And then we have an agreement that, okay, after this development, if any IP or invention comes out, then it will be a joint declaration as well as patent with the both assignee. Up to that, everything is okay, and we have the agreement. But it didn't went right all this through. In between, I was surprised to see they filed a patent, particularly patent application, on that particular membrane, using, perhaps covering our solution, and I will say treating our solution, a medical solution. So that means they told, okay, we are using our membrane, and it is your solution. You can't do anything. It's outside the scope of your agreement. So we have to do the reactive damage. We have to consider it as a reactive thing, and we have to close the agreement before actually it went past 1 year. Because more you disclose, more you actually fight with them, they will try to take it out and get their own patent and probably approaching our competitors. So reactive, as she mentioned rightly, the reactive damage and reactive, I will say, the action is the last resort we have. And we have learned that, okay, nowadays we will not do like this. That proactive, what we can do, we will share the knowledge with the third party who is developing the technology for us. Maybe university. Suppose university risk is less because they are not bothered about the patent, they will publish. There's another risk. They will try to publish in the form of the literature or journal. But if there is a service company we are collaborating with, the risk is that they can be over smart and applying for the patent, or actually know how and then passing. Because we know that our employees we can teach. But we cannot teach their employees. And it is nowhere agreement is written. So what is happening? We are now with the new agreements, whatever the agreements is there, but what is not written, it is in my head. I will not share the information more than that is stipulated amount that is only required. Even solution that we are using, we will not disclose the composition. For what we are using this medical solution, we will not disclose. I know that is a problem for them. They told that if you are not disclosing, how do you know? Yes, but there is a gap in between we have to mitigate. We will not tell what you can do. Because we have to save ourselves. This is the business is money, and I need to be compliant to my company. Because I have been paid by Baxter. I am not paid by the third party who actually is doing the collaboration with us. Right? I think this is the one of the mitigation plan. Others also will have similar example, I believe.
So I will talk about what I do at Open Invention Network. We try to protect Linux and open source. When I say Linux and open source, we are talking about 3,885 softwares and applications. If you are having an Android phone in your phone pocket, that's one of the softwares we protect. So the objective is there are entities like patent trolls and operating entities. So Linux and open source is fundamental technology. And if this fundamental technology is not protected, there will be no end to litigation. So how do we do that? So whether you are a project, you are a startup, you are an individual contributor, you are a company, anybody can join the community. You take a reciprocal pledge in the form of e-license that in case you have a Linux platform, so even if you don't have any patents, you can still join the community. In case you have a Linux platform patents, you will not assert it against the community member, and you get a reciprocal pledge from the community members. And in case you are sued by an operating entity, we provide you patents, which we have in the pool. In the past, one of the largest proprietary company sued TomTom and Canonical. When they were sued, both were cash rich, patent poor, typical case scenario. When they joined the community, that company withdrew the case within 72 hours. And 3 years back, they also joined the community. And in case of a non-practicing entity, what we do is we provide you prior art. So in the year 2019, Genome Foundation, which is an open source foundation, was sued by a patent troll called as Rothschild. So when Rothschild sued them, they expected money from Genome Foundation. But Genome Foundation, being an open source foundation, don't have money. So they joined the community. We gave them prior art. They went for crowdfunding. And with the crowdfunding, they went for invalidation using the prior art Open Invention Network gave them. So with that, once the invalidation proceeding was initiated by Genome Foundation, they withdrew the case. Because once the patent gets invalidated, it's of no use. So they gave a settlement offer where all the patents, not only the alleged infringing patent, they gave license to all the patents which Rothschild had. And after some time, after the matter was settled, somebody went and invalidated using the same prior art we gave to Genome Foundation. So that's how we come into the picture on the open source and Linux ecosystem. Now coming to the other ecosystem which I'm part of is called LOT network. So both are defensive patent strategies. LOT stands for license on transfer. Any LOT member sells any patents, any technology. A patent troll buys those patents. Once the patent troll buys that patent, it cannot assert it against any other LOT member because there is a license on transfer. So this way, we are keeping millions of patents away from the hands of patent trolls. So today, if you see, from an Indian context, you would be wondering, there is no patent trolling in India. But if you see, most of the Indian companies, SaaS companies, like Zoho has 20 litigations from patent trolls. Freshdesk has 10 litigations. Patent litigation is a very sensitive and, the litigation happens. I'll give you one more example. One of the largest Indian towel manufacturer was sued just before the Thanksgiving time in US. Because that's when it hits them most. So they would try to settle it. So please understand that the risk is from, not from a short-term perspective. You don't know when the patent trolls would come after you. And most of the cases, what we see is that there is a settlement. But most of the times, if there is settlement, you are a low-hanging fruit. More patent trolls will come after you. So please don't settle. If you fight back, so you could take the example of Zoho. Zoho initially used to settle. But once they fought back, no patent trolls come after Zoho. But if you settle with patent trolls, All the patent trolls will come after you. And most of the patent trolls, if you will be astonished to see, they are funded by the VCs. So the biggest VCs in the world you could see, they are funded by them, because that's the most money-making business. And in the latest technologies, that's the best area of money-making. It's better than real estate globally. So that is the risk from the patent side, how you can mitigate. Now coming from the copyright aspect, we discussed about open source compliance. There is a community called as OpenChain. OpenChain is a Linux Foundation project, where you are given the complete ISO standard, which is OpenChain 2.1 has been considered as an ISO standard, accepted as an ISO standard. How do you ensure that in the complete supply chain of software, you can ensure compliance? So you will have an open source policy. You will conduct periodic training to your employees, because that's one of the most important things. Most of the tech employees don't understand copyright, trademark, patents, the difference between the two. What is a license? What is an open source license? What are the obligations? What is the obligation if they are using a GPL3 license? What is the obligation if they are using a AGPL license? Can a copyleft license and a permissive license work together? No. There is different obligations in each of them. In GPL3, there is a patent grant back. So you could not use it for a product which is being commercialized. So I'll give you an example here. Cisco acquired Linksys. And when Linksys was acquired, the M&A team did not look into the license under which Linksys was running. Linksys was asked by Software Freedom Law Center to comply with the GPL requirement. They did not do that. They were taken to New York District Court and sued. And if the merger and acquisition team had looked into the risk from open source non-compliance, the price Cisco would have paid, and Cisco, which has the best legal team in an M&A transaction, did not look into it. And they had to pay a premium. They could not sell that as a proprietary software because there is GPL inside that. And they have to pay a huge amount of compensation, damages, reputational risk involved, and also, end of the day, comply with the GPL requirements. So that's why it is very important that today, most of the M&A transactions, I don't see open source audit being done. So you could give a different pricing to the acquiring company if you look into this. And the end of the day, you have again to do compliance, and that's a very tiring process. So it's better to mitigate that risk earlier on. The other risk which I see commonly is from the employees. Employees don't understand what is confidential, because the company also doesn't say that this is confidential, this is not confidential. Any document you'll see, it will not be written on the top.
That all of our employees do understand what they're signing up for when they join the organization. The do's and don'ts basically are translated in as simple terms as possible to the person on the ground who's involved in product development, who's involved in providing services, so that they have something like a ready reckoner. If I do this, I'm on the right track. If I don't do this, I'm on the wrong track. And then we also help them course correct as required. For product owners especially, we guide them on a couple of parameters. Let's say that in one part of the organization, you are developing something, let's say in the banking space, the manufacturing space, the financial space. In a different part of the organization, there might be exposure to a competitor of the same product or solution that you are developing, right? Now, how do you keep these two worlds separate? There should be ring fencing measures in place such that the person who's developing the product is not in touch with the team that is providing services to a customer or one or more customers to prevent any contamination to that particular product or solution by way of this third-party exposure. So you have to keep these two worlds separate. There have to be infrastructure, there has to be infrastructure-based ring fencing. There has to be awareness on both sides of the teams. This team should not talk to that team and vice versa. As Biju also mentioned, third-party compliance and open source compliance is also a very important part of the product development space. we cannot be in a situation where you've launched a product into the market and then somebody comes back and litigates with you saying that there is some form of non-compliance. So there needs to be measures in place before the product is marketed or sold or launched. All of these gate checks have to be passed. We also advise our product owners to carry out freedom to operate as well as landscaping exercises, IP landscaping exercises. From a freedom to operate standpoint, they should be aware of what are the active patents in any jurisdiction where they would like to market or sell this product. And from a landscaping perspective, they should also be aware of the white spaces available. What is competition filing for? What is customer filing for? What is partner filing for? And keeping all of this intelligence in mind, what are the threats and what are the opportunities as well? On the services part of the organization, when the services team is exposed to organizational IP, to third-party IP, and to customer IP, what are the kind of terms of use that are mentioned for any such IP in a master services agreement or in a statement of work? And how is the team having the right access or the right usage of any IP that is used in a particular engagement? Hence, what is important is the legal team, the service delivery team, the product team, if there is TCS IP involved or any other form of IP involved, we take care of all forms of IP, not limited to organizational IP. But also, what is the marketing team aware of or not aware of? What is sitting on a particular website? Is it in sync with the product literature that is developed and documented by the product team? Is it in sync with the kind of services that we are offering to our customers? Is all of this in sync or not in sync? And at a regular frequency, as Biju, Tarak and Madhuri have also been amplifying, it is very, very important to carry out audits to figure out what is the weakest link in the ecosystem at that point of time. If your weakest link is plagiarism related issues, go in for a very strong copyright governance system. If your weakest link at any point of time is lack of patents or not a very strong patent portfolio for your product, go into that direction and strengthen your patent portfolio, keeping in mind the FTO risks and the other landscape risks that I mentioned earlier. If your weakest link is people and process, look at what additional training program your teams need to know. As Biju mentioned, while people are aware of the need for a good open source compliance, not everybody is aware of those license issues, the interplay between a permissive license or a copyleft license and things like that. So all these checks have to happen before your product or service hits the market, so that your customer and your partners are assured that what you have at the end of the day is a trustworthy ecosystem. We should not be seen as an organization that is only bothered about our own IP. Customers and partners and vendors who work with us need to have the assurance that when they are working with an organization like us, they are assured of a trustworthy ecosystem. Their IP, their confidential information is going to stay protected, and there is not going to be any exchange of information between different parts of the organization. They have to be extremely assured about the kind of ring fencing measures that we have. That means that when we are offering services to, let's say, a banking customer, Bank A, Bank B, Bank C, some of the contracts have contractual obligations that prevent a service provider's organization from mixing people. That means if a person has worked with a global bank in one part of the organization, and there's a competing competitor of the same customer that we are also working with, we need to make sure that we don't move people from this particular engagement to another, because there is always a risk of people carrying their knowledge with themselves. So what kind of cooling off restrictions need to be in place, whether it is a 1-year cooling off restriction or something that is mandated by the customer in this case, or there are self-imposed cooling off restrictions that the organization believes that 1 year, 2 year, 3 year, whatever the cooling off restriction is needed, keeping that sharing of knowledge beyond a point could be harmful. One additional point I think was mentioned in the previous session is the risk of oversharing. So our consultants have to be extremely sure that they are not getting away with sharing more information while doing the proof of concept or doing the prototype with the customer. It is important to talk about capabilities, but the internals of what they are trying to develop, which could be IP protected, should never be relieved. So there are many, many different measures at different stages, different toll gates, We apply each of these, carry out the audits, look out for leakage points, and then try to close the gap on the weakest link and any other leakages that may exist.
I mean, it seems like what I'm hearing and what I experience in my practice is that a majority of these risks can be proactively mitigated through a sustained education program, making sure that you're providing the training to the folks you're working with, so they're not oversharing, so that they're sharing at the right times. Let's turn this on the flip side. Are there any IP risks you would say are just acceptable in the course of doing business? It's a risk, but in the grander scheme of things, it's okay because business has to move forward, because we hear that from our companies all the time. You guys are too nervous. You're not letting us do our work. We need to move forward with the technology. We need to go to that conference. We need to publish. We need to present. You guys are overthinking it. So how do you manage that? When do you let things go?
If you would like to.
Yes, apart from the managing the risk, as she mentioned, that we have to anyway go through. And then how much risk is acceptable? I tell that every risk there is a mitigation plan, as Taruna also mentioned. But in practical, there is a loophole, obviously. You can educate all this employees and actually mitigation plan. And also Biju mentioned about that, how the court will save you if you don't have this, good planning of the IP education in your own community or But suppose that you have to go through at the end. How do you do? That is one thing only sure, that you have to file the patent and make the portfolio very strong. That means, suppose that 1 and 2 information can be leaked. You have to accept that. And if you don't leak also, suppose that from your 5-6 patent filing, there is the cricket match, 5-6 ball is the outswinger, then you know that 5th ball will be in swinger. Kind of that. Some of the computers definitely will predict that, so that let them predict and do that. But your portfolio building from the beginning should be strong. 1 or 2 failure will not affect you. So that is the one thing that I have think that, okay, even there will be a breach of NDA, there will be the breach of the confidential agreement between the company and the employees. There will be the lack of the IP education or awareness. They are actually will maintain the silo, but in silos also there is a problem that I need to share with that say other division. But if I share, more mouth, more information, and more probability of spreading it. But still, if the IP portfolio is robust enough, like that, it is easy to kill I would say even the lion or tiger. But in elephant, it's a big element and a very heavy weighted. It's not easy to actually easily you can with a one single bullet you can kill that animal. So that's why the good portfolio around that there will be also some of the patents that will secure the portfolio secondary boundary line what will say, and that is the only way to do that. Risk will be there. You cannot mitigate the risk completely, but you can have some plan B to minimize the, I will say, the ill effect or minimize the lose kind of thing. And that is all mine.
So I will answer this. We all know that when Samsung copied many things, designs and patents from Apple, that was a calculated risk which Samsung took. They knew that the litigation will be there from Apple. But the position from number 3 to number 1, they took that risk. And end of the day, business is to make money. They made money. They became the number 1 manufacturer of mobile phones. So such calculated risk businesses should be taken. But I'm not saying that we should violate IP of somebody else. But there is another aspect to it which we don't generally consider. There is insurance. So if we anticipate a litigation, we should make sure that much before the litigation arises, we are insured. So that could be some of the suggestions as lawyers we could think of. And we could anticipate in similar scenarios, what is the extent of damage, that risk, what will be the damage if you are taking that risk. So whether it is a reputational risk, if it is a reputational risk, I would not say that we should take that risk. But if it is a technology risk or leap of faith we are taking, I think that should be taken. And if we can cover the risk with proper legal strategy, looking at the right lawyers who have done that type of matters, and also having insurance or litigation funding for that, I think that is a proper way of looking at things.
Maybe I'll jump in. In the biopharma space, we see, especially in the therapeutic space, if we have a company that is bringing forward a solution, a therapeutic solution that is truly going to change the market and save lives, we often see companies launching the drug at risk, meaning they have a known freedom to operate problem, but nonetheless, they will launch. Prior to launch, they will usually put together some sort of formal or informal opinion based on an invalidity position, based on a non-infringement position, based on a non-infringement, based on claim construction position, and they will launch at risk. In the US, more so than I think in Europe, and I'm not entirely sure in other major jurisdictions, the likelihood of getting an injunction in the therapeutic space is very low because the courts look at the fact that by giving an injunction, you are actually limiting bringing a life-saving drug to the market. So these are further down the path, calculated, as Biju is saying, calculated risks that organizations take. And it's always a tension. It's always a decision to be made.
Right. In most of our organizations, we see that there's a legal department, there's an IP department, there's a risk and compliance group, and at the end of the day, there is a business team, right? Now, all of us are, in our own ways, trying to safeguard the organization, but at the same time, we want to make sure that business does not suffer. So what we do is we categorize risks into two buckets. Some are completely non-negotiable. For example, if it's an open source compliance or a security compliance kind of thing, we put it in the non-negotiable bucket. With some of the others, what we do is, as the IP department, we would place a point of view. The legal team presents a point of view, and the risk and compliance team may present a point of view. And in some cases, you may have an HR process also coming in. We believe in two things. One, educating the business head concerned here, because there's a product owner, but then there's a business head for that segment as well. Saying that if this is a risk that is on the table, in some cases, there is a leeway that the business head can take, that this risk is acceptable to me. I will inform the customer, and we will be extremely transparent that if we have to deliver it as per a certain timeline, delivering it to you, let's say that by mid-Jan carries a certain risk. If I have leeway of time, and if I can cover the risk for you, I will deliver it to you 15 days later. So that's the conversation that the business team has with the customer, sharing that transparency and going along. But like I mentioned, open source compliance, security compliance are a complete no-no. So, that's how we deal with these things. Like, at that point of time, see what is important. Is the delivery to the customer important, but is the customer aware that there is a risk involved and goes along with that plan of action, plan A or plan B, whatever it might be, and says that, yes, I'm okay with taking this risk, but you're also assuring me that 2 weeks from now, you would have covered that gap, right? So that's the way we operate. And the other aspect which I would put into the non-negotiable bucket, we also have a contractual obligations governance framework. So there are certain things that are clauses in the master services agreement and the statement of work which are non-negotiable, because in some cases, legal teams of both parties are involved, while our team, our business team may be willing to say that, okay, we will deliver this 2 weeks later, or we will close the gap 2 weeks later. The legal team of the customer may not be agreeable. So we try to make sure that, especially for those clauses that are sitting in our contracts, the governance framework and identifies who's the fulfillment owner for each of those risks, because otherwise there are indemnities, there are liabilities, there are warranties, related clauses in those agreements that may kick in if we don't fulfill the obligation. So there is one area where you cannot really go beyond the necessary due diligence and say, I can take a risk on that, because then the agreement kicks in.
So if we had to leave the audience with one takeaway, what would your advice be?
Plan well, keep your eyes and ears open, take in as much feedback, because teams do face challenges in meeting our compliance controls and compliance measures, and try to see how you can make it as simple and effective to deploy an additional control, modify an additional control, because if things get too stringent beyond a point, the team that is expected to go along, is going to start resisting, is going to get frustrated, so try to see how to make it as simple and effective for things to be managed on the ground and not over complicate matters. So.
Yeah, always have a best practices, global best practices. If you can do that, like for open source compliance, there is open chain. That's a global best standard. For you can also join communities, global communities like OIN and LOT, and take the benefit without paying any commercials for that. And also look at litigation and all these things also should be looked at from a PR perspective. Because same example, when Samsung had to go to trial, before that trial, they made sure the ice rink in that Texas region was sponsored by Samsung. So all the jury members would be influenced by the sponsorship of the ice rink by Samsung. So all the billboards you will find is of Samsung. So you are trying to manipulate, although that's not a good example, but you should have your PR team in sync. Because if you are going to do an offensive strategy, everybody in the company should be on the same, they should have a strategy. That legal strategy is very important, whether you play offensive or you play defensive. That's very important.
Last concluding 2-3 sentence only. Always in this venture is expect the unexpected thing. When I joined GE 2005, 16th of May, first thing that I have learned from my mentor, trust but verify. We trust our partner, we trust our employees, we trust these government bodies. Many things actually have been told by Biju, Madhuri and Taruna. But think of that, always keep an eye that everything is happening aligned to the compliance or not. Something will go wrong, but at the end, how much risk we'll take, how much risk we'll consider it's okay. But it's like that, no medicine is a perfect, there is a side effect. So like that, IP and patent filing, trademark filing, there's also a side effect, and we have to consider that. But if the benefit is more and risk is less, we'll always accept that risk. And that is the benefit for our company and organization. That's all from my 2 cents on my table. Thank you.
I'll add that being proactive, providing education to your teams, whether you're an external provider or you have teams internally, the more you can, it's like raising teenagers, right? The more you can arm them with best practices and good judgment, when you send them out in the world, you hope they make the best decisions given the facts in front of them. I think we have some time. Are there any questions from the audience? What keeps you up at night? Other than wanting lunch. Well, thank you so much for your time.
Great thanks to the panelists. I'd like to welcome Ms. Vidya Vikas from TCS to give away the gifts. Also, the lunch has been served in the area right outside the plenary session. And we are going to have a quiz right after the lunch at the plenary ballroom. So I'd request everyone to spread the word about it, and please be there for the quiz. Thank you.